All right, good morning, ladies and gentlemen. This is the December session of the Special Magistrate for the City of Oviedo for code enforcement. Today we have several items on the agenda. First, if any of you are here and plan on speaking today and you've not already signed in, you need to sign in. We do need your name and address. For those of you who have not been here before, let me explain a little bit about what we're doing here today. If you're here today and you've been noticed at the hearing and it involves you, then it's because the city has taken the position that you're in violation of one of the city's codes, either the Land Development Code or the Code of Ordinances. My job today is to hear the city and to hear you, and to decide whether there is indeed a violation, and if there is a violation, how we're going to correct the problem. So that is in essence what we're doing here today. The first item on the agenda is case CE 17-001913. Involves Ronald Dodson. The property involved is 917 North Lake Claire Circle in Oviedo, Florida. The parcel ID number is 14-21-31-MC-0000-3250. The alleged violation is a violation of Section 303.2 of the International Property Maintenance Code, which has been adopted by the city, regarding enclosures, and violation of the city's Code of Ordinances, Section 22-144, regarding public nuisances. And the brief description is allowing torn screens in a pool enclosure in a stagnant pool. Who is here to speak on behalf of the city? All right. You step forward, please. Who's going to be? Is there anyone here on behalf of Mr. Dodson?
I haven't seen him, sir.
All right. Would you state your full name, please, sir?
Yes, sir. Jim Orioles, Code Enforcement Officer, City of Oviedo.
Would you raise your right hand, Mr. Orioles? Do you solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. What do you have for us on this, Mr. Orioles?
Your Honor, I have on case number 17-001913, as Your Honor stated, 917 South Lake Claire Circle, violations of 303.2 of the International Property Maintenance Code and 22.144A5 of the Code of Ordinances of the City of Oviedo. I have 14 pages of evidence to present to Your Honor, if I may approach the bench.
Yes, please. Thank you. It's 14 pages, Mr. Orioles?
That's correct, sir.
All right, those have been received in evidence. Go ahead, Mr. Orioles.
The first piece of paper, Your Honor, is the property appraiser sheet showing that the property is in fact owned by Ronald Dodson, 917 North Lake Claire Circle. The second page is the copy of the applicable ordinances. On September the 5th, we had received a complaint. We went out and did an inspection of the property. I have two pictures here, Your Honor. As you can see, the pool is green, very green, about the color of the carpet here. And this picture is very hard to see, but it's the top of the enclosure. There's a large tree branch that has ripped out a section of the top of the enclosure and is coming through. There's a second picture that you can see clearer than that. There was also, at the time, a screen panel at the very bottom of the enclosure that was out, but that has since been repaired.
So this photo, which is not terribly clear, is the roof of the enclosure?
Yes, sir.
Is there an opening in the side screening?
No, sir.
All right, go ahead.
We sent a notice of violation dated September 6th, which required correction by September the 16th. The following page, Your Honor, will see is the certified mail receipt, and the next one is the signed green card by Mr. Dotson himself that was signed for on September the 8th. As Your Honor knows, on September the 10th, and 11th, we had a little weather issue in the city of Oviedo, and the hurricane came through, so we gave Mr. Dotson more time to correct the problem. On November the 1st, we went back out and did a reinspection. And this time, the two pictures, you can see the pool is still green. Although the pump was running, the pool is still just green as grass. You can't see anything on the bottom of the pool.
And the roof is still open?
Yes, sir. This picture is a better indication. You can see the roof is open on this picture.
That's the photograph taken November 1?
Yes, sir.
Okay.
We made out an affidavit of violation on November 1 and request for hearing and a notice of hearing and sent them out. And also, I hand-delivered on November 8th, I hand-delivered those documents to Mr. Dotson himself as attested to by the affidavit that's here.
Did he give you any indication why he would not attend today?
He didn't give me any indication of anything, no, sir. As a matter of fact, I'm quite surprised he wasn't here.
Okay.
I went out this morning, Your Honor, to take another inspection, and the pool is still green as grass, and as you can see, the roof is still in disrepair. The limbs are still coming through the roof. These violations have existed for 67 days, Your Honor.
67 days?
67 days, yes, sir. Some of that now is because of the hurricane, but I believe that there's been ample time for Mr. Dotson to effect repairs.
All right, anything else to present?
No, sir, that's all.
All right, I'm going to find first that all the required notices required of Florida statutes have been provided to Mr. Dotson. It is clear from the pool and from the photographs and from the testimony of Mr. Orioles that the pool has been green for some time, is still green, and that the roof is still open. Is there a fence around the property?
No, sir, there's not.
Okay. At least the integrity of the screen along the sides is still intact. That would really be a hazard to children in the area. It still poses some hazard for any child that comes through an unfenced lot through the screen and into a green pool. So I do think it proposes a hazard, and the fact that it's existed for 67 days is really remarkable. I'm going to find that the respondent is in violation of both Section 303.2 of the International Property Maintenance Code and Section 22-144 of the Oviedo City of Ordinances, in that this does constitute a public nuisance. The green pool poses not only a hazard to people, and particularly children, but the fact that the screen is open at the top allows mosquitoes to breed in the pool, which in these days of mosquito-borne illnesses poses a real hazard. It seems that Mr. Dotson has had ample time to comply, to correct the situation, to come in compliance, and hasn't done that. I'm going to give Mr. Dotson until midnight of December 18th, 2017 to bring the pool into compliance. If he has not brought the pool into compliance for that time, then I'm going to impose a fine of $75 a day until the pool is brought into compliance. Next item on the agenda is case CE 17-002418. Respondents are Ramon Laredo and Teresa Rivera. The property is 3435 Heirloom Rose Place, Oviedo, Florida. Parcel ID is 17-21-5QA-0000-1800. The violation is an alleged violation of the Land Development Code, Section 4.11, which deals with prohibited uses and specific exclusions, parking an unlicensed vehicle on the property. Who's going to be speaking to this today?
I am, Your Honor.
Anyone else going to be speaking to this today? All right, would you step forward, sir? All right. Mr. Orioles, would you state your full name for the record?
Jim Orioles, Code Enforcement Officer, City of Oviedo.
All right, and I assume this is Mr. Laredo. Would you state your name into the microphone, please, Mr. Laredo?
Ramon Laredo.
Ramon Laredo. Right, would you both raise your right hands? You solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
All right. We'll hear from Mr. Orioles first, and then Mr. Laredo, we'll hear from you. Okay? Go ahead. You can have a seat if you want, Mr. Laredo.
Good morning again, Your Honor. This is case 17-002418, violation of 4.11B1, unlicensed vehicle on the property, 3435 Heirloom Rose Place. This is a repeat violation, Your Honor. This repeat goes back to case number 15-000378, and I will present those documents to Your Honor. I have 18 pages of documents that I'd like to present, if I may approach, Your Honor.
All right, and Mr. Laredo has been provided with those. All right, thank you. All right, these 18 pages will be admitted into evidence as the city's exhibit.
The first document, Your Honor, will see is the property appraiser sheet showing that the property is owned by Mr. Laredo and Ms. Rivera. The second sheet is the violation.
Is it a residential property?
Yes, sir.
Okay. Go ahead.
The second document is the Land Development Code Section 4.11. It's in violation. The third document, Your Honor, is the notice of violation that was prepared and sent in 2015 that states under corrective action pursuant to Florida Statute 16206, if the violation is corrected and then recurs, or if the violation is not corrected by the time specified for correction by the code inspector, the case may be presented to the enforcement board even if the violations have been corrected prior to the board hearing, and notice must so state, and it does. On April 23rd, 2015, Your Honor heard the case and concluded that the property was in noncompliance. There was no fine administered, no administrative costs were sought by the city, and the respondent shall bring the property into compliance no later than midnight of May 8, 2015. Should the respondent fail to do so, then commencing May 9, 2015, he shall pay a fine of $50 per day per vehicle that the violation shall continue. The property was brought into compliance at that time.
Okay.
The next document, Your Honor, you'll see on October 31st, we got a complaint about a RV being in the street, and when I approached the front door of the building to inquire about the RV that was in the street with the car trailer that you can see in one of the pictures, I observed the Cadillac backed into the driveway with no license tag on it. I ran a David report on the VIN number of the vehicle and found that the vehicle did not have a tag assigned to it. We then made out an affidavit of repeat violation and a notice of hearing. We have a certified mail receipt and a green card signed by the respondent. Well, I'm sorry, it's signed by Francis Laredo. The car, as you can see, all these pictures of the car is still there, is backed in. The second picture, Your Honor, there's a tag put on the car, a PE699B. We ran that tag and found that that tag is no longer assigned to a vehicle, meaning that the vehicle is still unlicensed.
Now, what's the situation on this vehicle? That the tag is not assigned to that vehicle?
This is the next picture.
The one on the Cadillac?
Yes, sir.
And this is on November 9th?
Yes, sir.
I want to make sure I understand. The PE699B is not assigned to that Cadillac.
That's correct. And I also ran the same day, the next document, Your Honor, will see, I ran another report on the VIN number to see if there was a tag assigned to the vehicle, and there was still no tag assigned to that vehicle.
A stolen tag?
No, sir. Just probably an expired tag that had never been renewed.
All right. And when did you last inspect the property?
I last inspected the property, Your Honor, on November. Oops, I'm sorry. Wait a minute. On November the 9th was the last time I inspected the property. I'm sorry, November 10th, and the vehicle is no longer there. Just for due diligence, I did run a report this morning. The vehicle is still unlicensed, however, it's not on the property, or I couldn't see it on the property. The vehicle was in violation for 10 days, Your Honor.
All right, Mr. Laredo.
Okay, as he said, last year, 2 years ago,
Raise the microphone.
I came here, you told me what to do, and I did. I got about 6 months ago, the Cadillac was in the garage all the time. When we came back from Wisconsin, her car, the Volvo, white Volvo that you see in front of the car, the battery was bad, so I took the car from the garage and put it in front to start the car. But in 6 months that we spending with Milwaukee, there, the RV was packed with a lot of things. So when I received the order that I cannot have that car, I know I cannot have it there, but there were a lot of things there that I have to put in my garage, make a space for them. So while I was doing that, the car was there. When I received that, I said, what I did wrong? They told me I can have the car registered on my name. I have a title here that shows that the car is in my name. And I just was not using the car. There was the reason that there was not plate. So all that time, that car uses 20-inch rims, so the tires went bad, the rims, so they went down. I went to a friends that have a dealer. That plate that you see in the car was to move the car to try to fix the problem of the issue of the tires. Once I solved that issue, the car is gone. He cannot find the car because I don't have the car anymore.
Where is it?
I sold the car to a lady, and not now. When I got married, this lady from wanted the car. We agreed on that she was going to fly and pick up the car, but I could not wait for her because I was getting married in Wisconsin. So I just told her, you will have to wait. That's the reason the car never got my plate that is in my name attached to the car, because the car was being sold to that lady. I have no business, I have nothing. That's what you told me I'd done. All the cars that are in my house are registered, and that one was because of that. And I apologize that I forgot that I have to make the space quicker and put it inside. But my mistake was that I thought that I was not doing wrong, because I'm not dealing, I'm not doing nothing wrong. Every car that I use is registered as you told me. And I have more cars, but you told me I cannot have many cars in my house, and I don't have many cars in my house. What you told me to do, I did. My mistake was that I took it off to jump the other, the tires were bad, and I tried to fix it.
Well, how many days was the Cadillac sitting there without a tag?
Without a tag, it was, I completed getting out of things from the RV about 5 or 7 days.
Okay.
Yes.
And after you got notice that you were in violation, how long did it remain there?
Then immediately I say, okay, I can have this here, and I remove the car. I called the lady, hey, the car is ready for go. And she came and picked up the car.
And the tag that was on it?
The tag is from a dealer that is a friend of mine, that he lent me the dealer's place to move the car.
You realize it's illegal to run a car on the highways of Florida with a tag that's not assigned to the vehicle.
That place is for moving the car from one place to the other. That's the way the dealer uses it.
If the car is owned by the dealer, that may be true.
Okay.
Mr. Laredo, I'm a little concerned that this is the second time that we've had this conversation. This is a repeat violation. All right, anything else you have to present?
No. You told me that I cannot have cars like that there, and I hope I don't have cars like that. Right. Only one, and it was in the garage for a long time.
Well, all right. Thank you, Mr. Laredo. Anything else? Mr. Orioles?
Yes, sir. I'd just like to point out, Your Honor, that I ran this morning the VIN number of the vehicle, and the vehicle is still in the name of Mr. Laredo, and it's still unlicensed. So if he said he put a tag on it, the tag that he put on it was not a dealer tag. It was a tag that had just been expired, lost, stolen. I don't know, but it was not a legal tag. No, sir, it was not legal to have a vehicle, and the vehicle is still registered in his name.
Yes, Mr. Laredo, you wanted something to show? All right, Mr. Laredo is showing me a certificate of title showing that it was sold to a Ginger Barnes, B-A-R-N-E-S, it looks like, on 12/2/2017. So she may not have applied for a title yet. Thank you, Mr. Laredo. All right, I do find that there's 10 days of violation, and this is a repeat violation. Were I true to my order that I entered back in 2015, I would probably be assessing fines at this time of $100 a day. I'm not going to do that, but I am going to assess a fine of $50 a day for 10 days. So I'm going to impose a fine of $500 that must be paid no later than December 21st, midnight of November 21st. And the order that I will enter will give you the place to pay it. It will be next door here. It's $500 by midnight of December 21. Okay, thank you. The next item on the agenda is case CE 17-002179, Nicola Fitchner, personal representative for the estate of Lawrence O'Brien. The property is 1706 Canoe Creek Road, Oviedo, Florida, 32766. Parcel ID is 19-21-32 504-0000-5960. The alleged violations are violation of sections 303.1 and 304.13 of the International Property Maintenance Code, a violation of 4.15 of the Land Development Code, and section 22.144 of the Code of Ordinances. And the allegation is allowing a pool to remain in an unsanitary condition, allowing a fence to remain in a state of disrepair, and allowing a window above the front door of the house to remain in a broken state. All right, who is here to speak to that today? I am, Your Honor. Okay, Mr. Stevens. Anyone here to speak on behalf of Mr. Fitchner, Mr. and Mrs. Fitchner? Okay. All right, would you state your full name, please, sir?
David Stevens, City of Oviedo, Code Enforcement.
Would you raise your right hand, please, sir? You solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? I do. All right. What do you have for us on this, Mr. Stevens?
All right, Your Honor. This is regarding 1706 Canoe Creek Road, Oviedo, Florida, 32766. Case number is CE 17-002179. As Your Honor stated previously, the violations, first one being from the Code of Ordinances, 22.144, which is a public nuisance. From the International Property Maintenance Code, Section 3031, keeping pools clean. Section 304.13, every window being kept in good repair. Land Development Code, Section 4.15, stating fences shall be in the original upright condition with no boards missing. I have a packet of 30 pages for Your Honor. May I approach the bench?
Thank you. Yes, please. All right. I'm going to admit these 30 pages into evidence as the city's exhibit. All right, Mr. Stevens, go ahead.
Yes, sir. The first page that you'll see was printed out today. This is a property appraiser sheet showing ownership of Nicola Fitchner, the rep for the estate of Lawrence O'Brien at 1706 Canoe Creek. The next page is all the violations pertaining to the case. Next page, we started by receiving a complaint on October 2nd, 2017 of a broken window, fence in disrepair, and a green pool. First picture, although it's a little hard to see, it's the center window that is broken out. Next is the pool, condition of the swimming pool.
Also a lot of weed overgrowth around that.
Yes, Your Honor, that was taken care of in a previous case. Next pictures are pictures of the disrepair of the fence. The next is the notice of violation created on October 4th, 2017 with a compliance date of October 14th, 2017. Next is a certified mail receipt, followed by the signed green card. A reinspection on October 17th, 2017 shows the pool in the same condition as well as the window, and then the two pictures of the fence remain the same. As Mr. Royals alluded earlier, or stated earlier, because of the hurricane, we did try to give people a little extra time to secure materials and do what they needed to do. On October 18th, we sent a second notice of violation with a completion date of November 16th, 2017. Next is the certified receipt, followed by the signed green card. The next picture, it was taken November 17th, showing the pool not to be in compliance.
The pool is still dirty?
Pool is still dirty, yes, sir. The window is broken. And
Is still the window above the door?
Yes, sir. And then the last two pictures are the pictures of the fence. All right. An affidavit of violation request for hearing was created November 17th for today's date, December 7th. The next page, actually next two pages, Your Honor, are stapled together. This is the notice of hearing. It was prepared also on November 17th for today's date, December 7th. The next is the certified mail receipt, followed by the signed green card. The last pictures, Your Honor, were taken this morning, December 7th, 2017, showing the pool, the window, and the fence not in compliance.
All right. There is a screen around the pool.
Yes, Your Honor.
Is the screen intact?
Yes, Your Honor.
All right. Have you had any contact with Nicola Fitchner?
There's been none, sir.
Okay. Anything else to present?
That's all I have to present at this time, Your Honor.
Okay. First, I find that all the statutory notices and notices required by the city's ordinances have been given. It is obvious from the photographs that the pool is in a pretty serious state of disrepair. I can only assume, seeing that this is now in the ownership of a personal representative, that Mr. O'Brien died and that this property has been sitting. Do we know how long this property has been sitting vacant?
My understanding?
Yeah.
My understanding from the neighbors, Your Honor, has been September, when the lady moved out of the house.
Okay. All right, thank you.
Thank you.
Well, there's no question that the pool is in bad shape. At least the screen is intact.
Yes, sir.
Fence is certainly in disrepair to the extent that a child could enter through it. Then if the child gets past the screen, we've got all the hazards that go with a dirty pool. The broken window, it is a violation technically. I don't know that that poses a safety hazard to anyone, but the pool certainly does. I'm going to find that the respondent is in violation of Section 303.1 relating to swimming pools and 304.13 relating to windows, skylights, and door frames of the International Property Maintenance Code. I'm going to find that the respondent's in violation of Section 4.15 of the Land Development Code and Section 22.144, the public nuisance provision of the city's Code of Ordinances. Because the screen at least is intact, I'm going to allow a little more time than I usually would to effectuate repairs. Respondent is ordered to bring the pool, the screen, and the window into compliance no later than midnight of December 22, 2017. Should the respondent fail to do so, then fines may be imposed of $75 a day until it is brought into compliance. Okay. Next item on the agenda is case CE 17-002437. Respondents are Gary M. Larwood, and Carol Larwood. It says Living Trust. I'm assuming they're trustees under a living trust. The property is 1240 Allendale Drive, Oviedo, Florida 32765. Parcel number is 11-2-521-530D00-0180. The alleged violation is a violation of the Land Development Code, Section 411, relating to prohibited uses and specific exclusions, parking a boat between the front building line of the house and the street. Who is here to speak to that today? Okay. All right. Would you step forward too, sir? Mr. Orioles, would you state your full name into the record?
Jim Orioles, Code Enforcement Officer, City of Oviedo.
And I assume this is
Gary Larwood.
Gary Larwood. All right. Would you both raise your right hand? Do you solemnly affirm the testimony you shall give should be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Larwood? All right. Both having said yes, we'll proceed. Mr. Orioles, we'll start with you.
Yes, sir. Good morning again, Your Honor. Case 17-002437, 1240 Allendale Drive, for a violation of 4.11B2 of the Land Development Code. I have 19 pages of evidence to present to Your Honor, if I may approach.
Yes. And does Mr. Larwood have a copy?
Yes, sir, he does.
Thank you. Right. Will be admitted into evidence as the city's exhibit.
Your Honor, I'm also going to, in the presentation of this case, I'm going to reference case number 17-001878, and it'll be obvious to Your Honor why as I present the case. The first document is the ownership property appraiser sheet showing the ownership of the property is Gary M. Larwood and Carol Larwood Living Trust. The second document...
Right. Which of the parcels is it there? 16, 17, 18, or 19?
18.
18?
Yes, sir.
All right.
The next document is the Land Development Code, Section 4.11.
All right. Is this residential property?
Yes, it is, R1.
All right.
And the next picture is from September the 8th. That was the first time the property was in violation of 4.11B2. And case number 1878, the next document, notice of violation, was sent on September the 12th. The property was to be taken care of by September the 22nd. The notice said, pursuant to Florida State Statute 16206, if the violation recurs, if the violation is not corrected by the time specified for correction by the code inspector, the case may be presented to the special magistrate, even if the violation has been corrected prior to the hearing, and the notice so states, and the notice does state.
All right, slow down just a minute. You sent notice on September 12.
Yes, sir.
The violation was
in a different
corrected
case.
by September 22.
Yes, sir.
Okay.
In a different case.
All right.
And the next two documents are the certified mail receipt and the green card, and the property was brought into compliance.
Okay.
We did, however, send a notice of hearing to the respondent, and he called and said that he would bring it into compliance immediately, that he didn't know the violation and it would not recur, and we pulled the item from the docket and did not bring it in front of Your Honor.
So after September 12, 2017, He informed you it would be brought into compliance, and
it
even
was.
though it had been noticed for hearing in front of the magistrate, it was pulled from the docket because he
Yes, sir.
said it would be corrected, and
Yes,
it
sir.
was corrected
Yes,
by
sir.
September 22.
Yes, sir.
All right, go ahead.
Okay, on 11/2, we received the complaint, actually, and went out and saw that the boat was once again in front of the garage. The next document Your Honor has is the affidavit violation request for hearing. It was done on November the 2nd. The certified mail receipt is next, and the green card signed for is next. The next documents are from the 3rd, the 6th, the 7th, the 8th, the 9th, the 10th, the 13th, and the 14th. The pictures that were taken as I was going through the neighborhood. Mr. Larwood called on the 14th or on the 15th and said that it was now in compliance, and it was and has been since then. However, it was in violation for 13 days. Also, in two of the pictures, Your Honor can see there was another trailer brought in, just to add insult to injury. On the 8th, there's a picture of a second trailer. The 9th, and that was it. Just those 2 days. Oh, yeah.
Has it been corrected as of today?
As of today, as of this morning, it was corrected, yes. It has not been in violation since the last picture was taken, Your Honor.
All right, thank
That's
you,
all.
Mr. Orioles. Mr. Larwood.
Thank you, Your Honor.
Yes.
I think Mr. Orioles has done an adequate job in proving that there was violations. This is a tenant-owned property or tenant-occupied property. If you will note, Your Honor, that there is a lag in time between my responses. It's because of the address was incorrect. It took a while for a forwarding to occur. I responded as soon as I had gotten notice. So you see the 13th of November was when I actually received the second notice. So I just wanted to make that point.
So it's November 13th, you say that you got the second notice?
Yes, sir. And I called Code Enforcement Office on the 15th, I believe. I was unaware that the tenant had taken I talked to the tenant, and he said that he was cleaning out his garage, trying to organize it. And on the 2nd of November, I believe, is when that was occurring. And he had his kids there, and they were washing vehicles and so forth, trying to clean up and organize the garage. Unbeknownst to me, when I found out about it on the 13th, and I told him to remove the boat from the property, and he has done so, to my knowledge.
Are you going to have a continuing problem with this tenant, do you think, Mr. Larwood?
I'm sorry?
You say that property is now tenant occupied?
Yes, sir.
Or you think you're going to have continue to have this same problem with this tenant?
No, I think he's got the message.
Okay. All right. Anything else? Mr. Orioles?
Only so that we did mail the notice to the address that's given by the property appraiser. That's the address by 162 that we have to mail. If Mr. Larwood wants it mailed to go there, a different address, he really needs to address the property appraiser and have them change the address on the property appraiser sheet. But we must mail it to the address that's on the property appraiser sheet, which is what we did.
All right. Because this is an alleged violation of the Land Development Code and not the Code of Ordinances, I'm fairly limited in what I can do today. I'm going to find that the property is, as of today, in compliance. I'm going to enter an order that it stay in compliance. And should it fail, should a violation again be noted, then I will impose a fine at that point in time, probably in the range of $75 a day. So you might impress upon the tenant, Mr. Larwood, the gravity of the situation. I could impose a fine at that point in time of $250 a day. I don't find that this creates a safety problem, but it certainly is in violation of the ordinance. So the property has to be brought into compliance and stay in compliance as of today, and should it fail to do so, I will entertain at another hearing to be set for the city a fine of $75 a day. All right, thank you. Next case on the agenda is case CE 17-001706. Respondent is Angela Pittman. The address is 585 Doctors Drive, Oviedo, Florida 32765. Parcel number is 15-21-31-501-0000-0070. Alleged violation is two sections of Oviedo's Code of Ordinances. The first is Section 22-19, prohibiting open storage, and Section 22.45, general requirements. The allegation of the city is that respondent has allowed the accumulation of junk, debris, and an unlicensed or inoperable vehicle to remain on the property. Mr. Orioles, are you going to be presenting this one?
Yes, sir, I am.
Okay, Jim Orioles, would you raise your right hand, Mr. Orioles? Solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
Is anyone here on behalf of the respondent, Ms. Pittman? Do you know why they're not here today? They weren't here at the last hearing either.
Sir, I have no idea.
All right. Mr. Orioles, go ahead.
Your Honor, I have 7 pages of evidence I'd like to present to Your Honor.
All right.
Your Honor,
heard admitted into evidence as defendant's exhibit. I'm sorry, petitioner's exhibit. Go ahead, Mr. Orioles.
Your Honor heard this case on October 26th and found the property to be in non-compliance, ordered to be brought into compliance by midnight of November 24, 2017, or a fine of $75 per day for each day a violation shall commence. We sent a notice of right to hearing to Ms. Pittman.
She got a copy of that order?
She got a copy of the order.
Okay.
As a matter of fact, I believe she made a phone call this morning saying her property was in compliance. However, I have pictures taken on the 27th, which was the day. The 24th was a Friday, so we could not inspect on the 25th or 26th. We inspected on the 27th, and Your Honor can see that the property is still in non-compliance as of the date specified. And as of yesterday, I don't have a picture to show Your Honor, but I can testify that as of yesterday, the exact same condition was present on the property. And affidavit of non-compliance was filled out and signed on November 27th.
What is the zoning on this piece of property?
It's a residentially zoned piece of property. I think it's R1A.
This looks almost like a vacant lot. How large a lot is this?
It's a very large lot. I'm not sure exactly what the property appraiser, I don't have the sheet with me, but the property appraiser has it as acreage. I'm not sure how big a piece of property it is.
Did this come to your attention from a complaint?
Yes, sir. Came to us from a complaint, sir. It's back behind Jackson Middle School. It's not.
Sorry?
It's back behind Jackson Middle School. It's not an area that is normally a high traffic area. We don't go back there that much, but we received a complaint on it.
Could you, when you visited yesterday, could you see any difference between the November 27 photograph?
No, sir.
What you saw today?
No, sir. From the October hearing, there was 2 cars present at the October hearing. There was one that had been removed, but there was no difference.
And I see this is a Massey request today for
Yes,
the
sir.
imposition of a fine.
Yes, sir.
All right. I did enter an order on November 24th, 2017, setting a date for compliance of no later than midnight of November 24, 2017. As of December 6th, yesterday, that would have been a total of 11 days of noncompliance. At $75 a day, that's a fine of $825. I do find that the respondent has not come into compliance with the order dated October 26, 2017, and at least as of yesterday was still in noncompliance. And there's hereby imposed a fine of $75 a day for 11 days, or $825, which will constitute a lien on the property. Also, because this is a Massey hearing, this fine will continue to accrue. In fact, pursuant to Florida Statute Section 162.09, subsection 3, the $75 a day shall continue to accrue until the respondent comes into compliance.
Yes, sir. Thank you.
Okay, thank you. All right. Last item on the agenda is KCE 17-001184. Respondents Roy C. Jones and Judith M. Jones, TRS FBO. The property is at 201 West Mitchell Hammock Road, parcel ID 15-21-310-0570-0570-0000. Allegations of violation of Code of Ordinances, Section 22-144. Actually, at the last hearing, the last order really dealt substantially with the issue of the proper zoning for this zoning classification for the property. Who's here to speak to this today?
I am, Your Honor.
Okay, Mr. Orioles. Anyone else? All right, everybody that's going to speak today, step forward and state your name into the microphone.
Jim Orioles, Code Enforcement Officer, City of Oviedo.
Okay, Mr. Jones.
Roy Jones.
Right.
Natalia Jabłońska.
All right, would you raise your right hand? You solemnly affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth.
I do.
All right, Mr. Orioles, we'll start with you.
Your Honor, I have only one piece of paper, one piece of evidence to give to Your Honor, and that's evidence presented to me by Mr. Jones. We had a meeting in Development Review. My intention was to come this morning and advise Your Honor that there was not enough time given at the last hearing for a change of zoning or a deviation to be sought from the city. I was going to request more time on behalf of Mr. Jones to do that. However, since that time, I was told by the tenant that they would be moving out by February the 1st, and I was also given a paper, which I will present to Your Honor if I may approach, that Mr. Jones served on the tenant an eviction notice effective December 31st.
All right. All right, and this is something for my file?
Yes, sir.
All right, I'm going to introduce that into evidence. As the city's exhibit. So, as you understand it, Mr. Orioles, the tenant stated that they were moving by February 1,
Yes, sir.
2018. Since then, you've received a copy of eviction notice, which would make the eviction effective December 31st.
That's correct, sir.
All right? Anything else you have to present?
No, sir.
All right? Who is next to speak?
We got that letter from Mr.
You're going to have to slow down a bit. You
Okay.
tend to talk fast.
We get the letter from Mr. Jones, and the same day I asked him to come into the place and talk to him. And I asked him if the city is going to agree for us to stay till the end of February. We are going to have more time to find new place and move. If he's going to agree to that, he said yes, if city is going to agree to that. And I called Mr. Orios, and I asked him if it's going to be fine with the city if we're going to stay till the end of the February. And he said that they would support that decision. We already found the land, and we are in the process of buying it in Cocoa. So, but we need a little bit more time, till the end of February, since Christmas coming and New Year's Eve.
So,
I would like to ask for the time that city will agree for us to stay there till the end of February.
so the Joneses and the city have agreed that you
Yes.
can stay until February 1st.
Yes. And we are gonna try to move earlier as soon as possible, but it's 1 hour drive one way, and so it's a little bit lot of stuff to move there.
All right. Yeah, incidentally, when at our last hearing, you gave me a photograph of another piece of property. I think it was Auto Nation.
Mm-hmm.
They do indeed have a special exception
Oh, okay.
with their zoning. Okay. Okay. Anyone else have anything to present? Yes, Mr. Jones.
You have a copy of the eviction notice. It was,
The eviction notice? Yes, I have that.
yeah,
yes.
this, Evelyn Cloninger, attorney. So that's what we've done. Because of your last ruling, it was like trying to get the zoning changed. The issue was like, is this manufacturing? Is this a salvage yard? And it's a gray area. It's not worth me. I don't think I could get the rezoning, and I don't think it would fit in anyway. The only option I had left is
Okay.
if I have to talk to my wife, but if it's all right with code enforcement, this deadline, with proper maintenance, I could go further. I think she's requesting to the end of February, right?
February 1. Oh, February 30th, or is it 30? How many? No, February 28 would be. Okay.
I think because this is, they are required to be out at this point, at the end of December. So I'm going to try to make sure that they are in agreement to maintain the place in the proper fashion.
Okay.
In the meantime, and I think with this eviction notice, it gives me sort of the power to make sure they're going and moving out,
Okay.
because there's other features at the last moment that are still sitting there. So I'll do my best.
All right.
And
So you and they have agreed that they will be out by February 28th.
I haven't actually agreed, but at this point, with conditions that I've checked with my wife, that we could go to the end of February if that's,
Okay.
but we need to see some sort of, I'll have to discuss it with them, some sort of progress so we make sure that it's happening.
Well, you do need to discuss that with your attorney, of course. She
Yeah.
needs to be in that loop.
Yeah, my attorney suggested that this is the legal thing and I wanted to do it in the amount of time which was required, given the notice, 30 days, there's no lease, and so I have this in hand. So this
Well,
gives me,
I suspect your attorney will want a written agreement with the tenants.
yeah,
If she extends beyond the December 31st,
right,
she will probably advise you to get a written agreement with the tenants for
Yeah.
the February 28th date.
right, okay. Well, thank you for the advice on that. So that's what we'll do.
Okay. Mr. Orioles, let me hear from you. I've heard from them, but is the city agreeable to this arrangement?
Yes, sir. A rezoning of the property or deviation would take longer than the February 28th date, so the city is satisfied with the February 28th date.
All right, what I'm going to do is enter an order reciting the testimony I've heard here today. That is that the tenant will evacuate the property by February 28, 2018, and that between now and then the tenant will keep the property in up to snuff, clean, no junk. And should the tenant fail to leave by February 28th, then I would ask the city to bring this back up for hearing. We'll consider whatever we have to at that time. I'm glad you found some sort of resolution. I'm sorry that it worked out the way it did, but no matter how I tried to stretch it, I could not put a square peg or a round peg in a square hole, or whatever you say. This property, the use of this property just did not fit the zoning.
Yeah, that's been here for a long time. Well, the way they operate, is in that kind of shady area between not quite fitting the repair and auto sales, because they deal too much in the wreck-type vehicles. And they've apparently, Natalia said they found a place near Cocoa where they can do what they want, what they normally do, and what they want to do.
That's good. I understood that this property really evolved over time. It began as a different type of business, really, based on what I have heard. And over time, there came to be more cars, more repairs. So, but in any event, I hope it works out for everyone.
All right, thank you.
Thank you. All right, anything else to come before us today? All right, we are adjourned.